Welcome back. Barely a month after a damning verdict by a US judge that has labeled Google an illegal monopoly in online search, the US government prosecutors have begun a second antitrust trial against the search engine, this time accusing it of being a monopoly in online advertising and controlling its related tech infrastructure. The hearing is underway in the district court in the Eastern District of Virginia. Our next report gets you more about what has happened so far.
The trial involving tech giant Google and the Department of Justice in the United States is continuing in a district court in the Eastern District of Virginia over what is alleged to be Google's monopoly in the ad tech space. Google stands accused of violating provisions of antitrust laws. On day one of the hearing on the 9th of September, the US government cited Google's acquisition of DoubleClick, an advertising software company, which has over time enabled Google to acquire a dominant market share in ad-selling technology, which has allowed it to sell ads at higher prices, something that has allegedly hurt news publishers and website owners. Day 2 of the trial featured testimonies from several industry voices about Google's ad server for publishers, formerly known as DFP, as well as AdX, Google's ad exchange, which is exclusive to Google's ad server. Stephanie Laser, who was once associated with News Corp and now works at Amazon, described DFP as slow and clunky. Ezer Lipkowitz, who was associated with Google for 15 years, described the team working on DFP as lazy and slow in terms of innovation. This was to drive home the point that despite complaints about technology, Google's ad server had a massive market share. For example, it was mentioned in court that News Corp tried to look for an alternative ad server as a replacement for Google in 2017. Its assessment showed that it losing Google's advertisers could have resulted in a $9 million loss in ad revenues for News Corp. As per data from 2016 cited in court, AdX, Google's ad exchange, accounted for 52.7% or $43.9 million of News Corp's programmatic revenue that year. This made it impossible to negotiate with Google because of the losses one would incur for not doing business with it. For those who did try to negotiate with Google over their ad access rates, there was refusal from Google. The CEO of marketing agency Goodwill Group testified in court saying that his company did raise the issue of ad access take rates that were higher than the competition, but provided the same quality of advertisers, but no proper negotiation was forthcoming. So, is Google really operating like a monopoly and adopting a my way or the highway approach? One would have to wait and see how Google responds to these claims in court. But Google's defense is that the Justice Department's actions may result in more inefficiency and even higher prices that could potentially hurt small businesses in the United States. Already having suffered one judicial setback earlier this year in a case involving online searches where the judge in the District of Columbia noted that Google is a monopolist, it remains to be seen how these latest proceedings now progress. News Desk, Times Now.